a practical guide to civil procedure in Ghana. Now, we respectfully submit that the same approach of this court in Republic and High Court Ex parte Magna International Transport, that same approach is found in this court's decision in Mona and the Attorney General. Where again, that is 2013 Supreme Court of Ghana Law Report, page 502. That court was faced with an issue arising from an amendment to Rule 55. And that amendment was by reference to Rule 71B in CI 74. And as it turned out in that case, Rule 71B actually had a heading, no review, suggesting that it was purposing to prevent reviews. And this is what the lordships concluded. And I refer to the judgment of Justice of the Supreme Court Benin at page 512. Thus, when the Rules of Court Committee was charged under Article 64(3) of the Constitution with the responsibility of enacting rules to regulate the conduct of the practice and procedure in presidential election petitions, it meant the substantive laws were different from what the committee was empowered to do. The committee was not empowered to amend the substantive law without express authorization. One such substantive law in place is the right of review given to the Supreme Court by virtue of Article 33(1) of the 1992 Constitution. Review is not a matter of mere procedure, but an important and substantial constitutional right. Any attempt to alter the right of review will be ultra vires the functions of the Rules of Court Committee. And any attempt to remove the Supreme Court's review jurisdiction or a party's right to apply for review, except through an amendment following due procedure under the 1992 Constitution, will be unconstitutional. Now, Lord, our argument is by parity of reasoning. We're not saying that exactly the same circumstances are here. We're saying that by parity of reasoning, if there were intended to be a repeal of a well-established process, such as the pre-trial process of interrogatories being filed, or other discovery processes, if there were an intent to do that in CI 99, it would have had to be very express in order to achieve that result. That result cannot be achieved by means of an implication being drawn that the timelines do not allow for that.
Mr. Chikata?
Yes.
Is there a difference between a constitutional provision that is impliedly taking away because of CI, and a provision that is resorted to in order to do justice. Is there a difference? I'm thinking of your parity of reasoning, and I'm wondering why you would compare apples and oranges in that way.
My lady, as I indicated, we are not suggesting that they're exactly the same circumstances. But in each case, in the case of the ex parte magna authority, which says that there can't be an implied repeal, in the case of the Bernard Mona situation, which says that a rule of the Rules of Court Committee cannot take away a constitutional right. In each case, we are talking about an existing right, an existing practice and procedure. If it is being sought to be taken away, one, as ex parte magna says, it has to be explicit. It can't be done by implication. And two, in the case of the constitutional situation, the position is that it cannot even happen at all. So that is in extremis. That is in extremis where it is simply impossible. But I'm saying that...
That is why I'm wondering why you will compare a situation in extremis with the situation that you are talking about and reasoning that is by parity of reasoning.
Because in principle, in both cases, you do not have an express repeal of an earlier CI. You do not. In both cases, there isn't. In fact, that is why in the Bernard Mona case, even though the Rules of Court Committee may have thought that they were taking away the power of review and they put no review at the top, even though they put that, the court decided that it did not have that effect. Because looking at, and my Lord, again, this is a matter of looking at the language. The Bernard Mona decision is absolutely on all fours because the court looked at the terms of the amendment. The terms of the amendment showed clearly that it was not seeking to review. I'm sorry, it was not seeking to take away the power of review. The terms, and we are saying respectfully that the terms of CI 99, nowhere do the terms of CI 99 seek to take away the power to have interrogatories served in Order 22. So there is a clear parallel because the court is saying, let us look at what the so-called amendment is trying to do. Let's not even bother with the heading. The people in the Rules of Court Committee may have thought that they were taking away the right of review. But let us look at the words. And those words did not indicate that the right of review was being taken away. In the same way, we are respectfully saying to your lordships that the words in CI 99 nowhere say that they are taking away the powers under Order 22 of CI 47. Nowhere. And I would respectfully challenge anyone to point to any provision in CI 99 that seeks to take away what is provided for in Order 22 of CI 47. And my lords, we would respectfully also draw your attention to the provision in Article 1294 of the Constitution, which states that for the purposes of hearing and determining a matter within its jurisdiction, and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary indication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So it is without a shadow of doubt that those provisions in CI 47 or the 22 in respect of pretrial procedures, those provisions are available to the Supreme Court. And it is on the basis of those provisions that the Supreme Court in 2013, in a petition brought by Nana Addo Dankwa Akufo-Addo, had recourse to Order 22 of CI 47. Our submission is that it cannot be that just because this petition is by John Dramani Mahama, it cannot be that it cannot be.
Mr. Chigata, please, let's try to.
It's okay. Respectfully, my argument is that there cannot be a different interpretation of the law.
With due respect, if the 2013 case is cited, then it will be clear to all of us. That's my worry. What I'm saying is that if it is a reported matter, yes, if it is cited in a course of arguments, yes, that will be the appropriate thing.
Mr. Chigata, and additionally, the 2013 election petition was not done under CI 99. So that is the change, rather than the personalities involved. I think you
Yes, my lords, I believe I have indicated that nothing, that's my first argument, nothing in CI 99 took away that authority. I've indicated that. And therefore, and building on that, I'm saying that it cannot be any different from one petitioner as against the other. We'll leave out the names of individual petitioners, but it cannot be different as between one petitioner
Mr.
or the other.
Can you explain to me how come the Rules of Court Committee was seized of this matter after 2013 and still did not make this provision?
And still
did not make this specific provision that you are saying somebody benefited from, and so everybody must benefit from. How come the Rules of Court Committee had another opportunity to make rules and did not say anything about it?
My lords, as I've indicated in answer to your previous question, I frankly have no knowledge of the deliberations of the Rules of Court Committee, and I'm not, with respect, willing to go on an expedition into the minds of the membership of the Rules of Court Committee as to how come they did this or they didn't do that. That, respectfully, is completely outside my terrain. What is within my terrain is what they have provided in CI 99. And in CI 99, nowhere do they say Order 22 is repealed. Nowhere.
CI 99 has repealed Order 40, Order 22, or CI 47. We just said that. You just read the ruling, the basis of your grant A. We are strictly bound to comply with CI 99, and therefore we will not apply Order 22 of CI 47 of 2004. We did not say CI 99 has expressly or impliedly revoked or repealed Order 22. Mr. Speaker, if you allow me to lie, we're just saying that we cannot apply, in the circumstance of this case, we cannot apply Order 22 on interrogatories. That is all that we said. We never alluded that CR 47 Order 22 has been amended or repealed.
Yes, but my Lord, with the greatest respect, if the circumstances are no different, my Lord, may I finish my sentence? If the circumstances are no different, except for the fact that there is now CI 99 providing a certain timeline for decision making, we are submitting that Order 22 is still capable of being operated within the timelines that are given in CI 99. Nothing stops Order 22 from being implemented and the timelines not being complied with. Nothing.
If you note, the very first reason in the ruling of the court is that the crucial issue of relevance has not been established in the petition. That was very clear.
And that crucial issue of relevancy is referred in the ruling paragraph, the sentence just before that. Interrogatories under common law is discretionary. It should be granted or refused. Interrogatories under common law. We did not seek interrogatories under common law. We are seeking interrogatories under Order 22 of CI 47. And we are saying with respect, that if it is a question of relevancy, I mean respectfully, if it is a question of relevancy we are talking about, how can it not be relevant that an interrogatory that seeks to ask, for instance, question 7, when did Mrs. Jean Aduko Mensah, the chairperson of first respondent and the returning officer for the presidential election, first realized there were errors in figures she announced in her declaration of 9 December 2020. 8. How did Mrs. Jean Aduko Mensah, the chairperson of first respondent and the returning officer for the presidential election, get to realize there were errors in figures she announced in her declaration of 9 December? 9. In respect of the purported corrections made to the figures in the declaration by first defendant, was there any prior process of conferring with agents of the presidential candidates? 10. Did Mrs. Jean Aduko Mensah, the chairperson, present Form 13 to all the agents of the presidential candidates to sign? And if so, did all the agents sign? 11. On which date did Mrs. Jean Aduko Mensah, the chairperson of the first respondent, post a copy of the Form 13 at the head office of the first respondent? 12. Did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the result? How can it possibly be said that none of those questions, just to give examples, none of those questions is relevant to the determination of the suit? A suit in which
You are not saying that those kinds of questions cannot be asked in cross-examination.
my lords, we have never said those kinds of questions cannot be asked in cross-examination. In fact, when it was suggested by counsel on the other side during the hearing of the application for leave that they can be asked by means of cross-examination, we made it quite clear that in fact, being able to have those questions addressed in interrogatories saves time. Because then you don't have to go into them in cross-examination. Why would I spend, questions in cross-examination dealing with something that has already been answered on oath? That is why we say that we have been practically guided by that wisdom, that if it is stated on oath, we put it in as evidence, so we don't need to cross-examine about it, because it's already been determined on oath. So why would we go into cross-examination? I fail to see how it does not expedite justice to have the matter answered in an interrogatory rather than wait for cross-examination to do that. And the reason I respectfully say that we are guided by the practical wisdom in Mrs. Mafusa's book is that if you prepare your case, part of the preparation is anticipating what you might do in the examination in chief of your own witnesses and what you might wait to do in cross-examination. But in preparing our case, we thought it important to have those questions dealt with in interrogatories so that we will not be burdened to have to ask them subsequently in cross-examination. In any case, Your Ladyship, if the questions are not relevant, how can they be allowed in cross-examination? If that is the position, if the questions are not relevant, if that is the position that's been taken, then they can't be asked in cross-examination either.
Are you attempting to cross a bridge you have not reached?
Well, I believe you put that bridge there. Your Ladyship put that bridge there, and therefore I had to deal with that bridge. Your Ladyship raised the issue of whether it can be raised in cross-examination. And, respectfully, part of the reason why we cannot wait for that bridge in the preparation of our case is that in putting forward our case, we absolutely need that evidence. It is material to our case. And we need that evidence so that we can put it in as part of our affidavit, as part of our witness statement. And we respectfully ask your lordships to grant the relief. Indeed, my lords, as we indicate in our ground B and ground C, the ruling also claims that
Counsel, please, I think some of these submissions are captured in the statement of case.
Yes,
if you can highlight some of them so that you wind up.
I'm winding up. But I also had to respond to the questions of your lordships. My lords will see that it is stated that Rule 69C4 not only sets timelines, but it implies, and these are the words in the ruling, it implies that even amendments ought not to be sought and granted as well as joinder of parties. Now, my lord, so this is the legal basis on which that exercise of discretionary power is being exercised, that even amendments ought not to be sought and granted as well as joinder of parties. We are saying with the greatest respect that that is a fundamental error of law. Nowhere in CI 99 does it say that amendments ought not to be sought and granted simpliciter. Nowhere. No.
In any case, we granted an amendment.
I'm sorry.
We have granted an amendment in this case to the petitioner.
Because it is allowed in the rules.
So that is not what we meant.
No, but that's what is stated. In the ruling it said it implies.
The rule does not allow amendments, substantive amendments to the grounds.
My lord, I just read from the ruling. There's no qualification.
Yes, but that is just as you said, you can't go into our minds. You can't go into the minds of the rules of core committee members.
But we can go into the letter of your ruling.
Yes, so that is not what we meant. The rules does not allow substantive amendments to grounds and all that. We would have granted you the amendment that you sought.
My lord, at a minimum, what your lordship just said suggests that your Lordship should, at a minimum, review your ruling so as to qualify the reference to amendments appropriately. Because we expect nobody reading the ruling that you've given can see the word substantial in that. Nobody can see that. And in any case, in CI 99 does not, my Lord, with respect, I leave my submission at the point that that statement, as it stands in the ruling, is not borne out by CI 99. I leave it at that, and it is obviously up to your Lordship to determine ultimately whether indeed Rule 69(4) says or implies that even amendments ought not to be sought. My Lord, with respect, I mean, the amendment that we sought and that was granted, I mean, was a very insubstantial and frankly a clerical error which was corrected. That should not be touted as a reason for somehow not accepting the argument that we are making. My Lord, my final submission is that this court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution. And that Article 296 makes it clear that where in this Constitution or in any other law discretionary power is vested in any personal authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. We are respectfully respectfully submitting that in respect of your discretionary power to grant leave for interrogatories, there was, with respect, a duty to be fair and candid, and not to act in a manner that is arbitrary or capricious. And our respectful submission is quite straightforward in this regard. Our respectful submission, in terms of even a determination about the relevancy of the interrogatories as we have drafted them and the questions, in terms of a determination of relevance, your Lordship should at least have considered the questions posed in the interrogatories by reference to the issues in this case. Because if your Lordships had made that reference to the issues in this case and to the questions that we have posed, with the greatest respect, it would be perfectly obvious that those questions were legitimate questions that required answers to be provided. So it is not sufficient just in one fell swoop for it to be said that the crucial issue of relevancy has not been established. With the greatest respect, it is not. It is not an exercise of discretionary power consistent with Article 296 for there to be such a disregard of the terms of our interrogatories.
My lords, we are opposed to this application for review, and we rely on the depositions in the affidavit in opposition and the statement of case that we filed. My lords, under CI 16, Rule 54, the court may review any decision made or given by it on any of the following grounds: exceptional circumstances which have resulted in miscarriage of justice, or discovery of new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not have been produced by him at the time when the decision was given. My lords, the submissions that we have heard today have not canvassed any new matter or exceptional circumstances for which this court's review jurisdiction should be exercised. My lords, what we have rather heard was a rehashing of the arguments that was before the court when the decision was taken on the 19th of January. In this regard, my lords, may I humbly read the decision of Adade GSC in the case of Mechanical Lloyd Assembly Plant versus Nati, reported in 1987-88, 2 Ghana Law Report 598, Supreme Court. My lords, with your kind permission, it says, let me say at once that for all I know, virtually every judgment on this earth arrived at as a result of evidence gathered from several sources can be criticized. A Privy Council judgment put in the hands of any lawyer along with the evidence grounding it can be criticized in the same way as a High Court judgment can be. A person who has lost a case will almost instinctively feel that the judgment must be wrong. And why not? If you had won, the decision will be right. So if you lost, how could the court be right? But the mere fact that a judgment can be criticized is no ground for asking that it should be reviewed. A review jurisdiction is a special jurisdiction to be exercised in the exceptional circumstances. It is not an appellate jurisdiction. It is a kind of jurisdiction held in reserve to be prayed in aid in the exceptional situation where a fundamental and basic error may have inadvertently been committed by the court, which error must have occasioned a gross miscarriage of justice. The review jurisdiction is not intended as a try-on by a party after losing an appeal, nor as an automatic step from an appeal. Neither is it meant to be resorted to as an emotional reaction to an unfavorable judgment. My lords, it is my submission that the arguments we have heard today by the applicant is just an emotional reaction to an unfavorable judgment quoting her today, and therefore this application should be dismissed. That's my submission.
My lords, we are opposed to this application, and we rely on the depositions in our affidavits in opposition filed on the 25th of January 2021 and our statement of case filed on the same day. My lords, we wish to make the point from the very beginning that the court grounded its dismissal of the application for interrogatories on 3 key points, and not as counsel for the petitioner has sought to suggest on 1 point. The court raised the issue of relevancy, the issue of lack of matters in controversy, and then made the point, the third point, that CI 99 establishes strict timelines, and therefore the application will not, therefore Order 22 will not apply in this circumstance. So the first myth that has to be blown away is that the court never ever said or implied that CI 47 had been repealed or will never apply in a petition, in an election petition. This is a gross misconstruction.
He said Order 22. Order 22.
Yes, Order 22 or CI 40. I'm saying that my submission is that this interpretation is a gross misconstruction and an impermissible gloss that counsel seeks to put on what the court said. Now, my lords, my second point here is counsel has raised the issue of relevancy. Now, the issue of relevancy goes to the issues to be determined in the trial. And if your lordships look at the issues to be determined in trial as set out, it becomes very apparent that these matters that were raised in the interrogatories are not really germane to the issues to be determined in trial. The issues are: 1, whether or not the petition discloses any reasonable cause of action; 2, whether or not, based on the data contained in the declaration of the first respondent and the second respondent as president-elect, that no candidate obtained more than 50% of the valid votes, as required by Article 63(3) of the Constitution. 3, whether or not the second respondent still met Article 63(3) of the 1992 Constitution threshold by the exclusion or inclusion of Techiman South constituency presidential election results. 4, whether or not the declaration by first respondent dated 9 December 2020 of the results of the presidential elections conducted on 7 December 2020 was in violation of Article 63(3) of the Constitution. And finally, whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election. My Lord, it is my submission that it is more than obvious that the issues sought in the interrogatories, are not really relevant in the determination of these matters. Secondly, my Lord, the court's second reason was that the issues sought in the interrogatories were not related to issues in controversy. That is, the issues joined by the pleadings. It is then only after these two fundamental reasons that the court makes the observation that in any case, or in addition, CI 99 prescribes strict timelines. Therefore, the court will not apply Order 23. In this circumstance, what is meant by this circumstance? That is, all the issues that have been looked at or discussed in the ruling. We all know that when you are doing interpretation, you do not just pick one sentence or paragraph out of a whole construction and make a meal out of it, as counsel for applicant seeks to do. My lords, let me then make the point that the reference to the Monarch case, my lord, is misconceived and involves a deliberate attempt to put an impermissible spin on the Monarch case for purposes of this application. In the Monarch case, what the court held was that that rule in CI 74 that sought to take away the right of review was unconstitutional. Now, in order that the petitioner can suggest the relevance of the Monarch case to the present application, he seeks to suggest that the CR 99 has impliedly repealed the right to interrogatories. That is the whole point. Now, if the court, as I've demonstrated, has nowhere said that CI 99 has repealed or amended the right to apply for interrogatories under Order 22, the whole argument of the relevance of the Monarch decision falls flat. It crumbles, my lord. Now, similarly, my lords, we believe that it is important to recognize the point that every application that is brought for interrogatories must be decided on its own terms based on the general principles governing the grant of application for interrogatories. Therefore, it is again misconceived for counsel to suggest that because in 2013 an application for interrogatories were granted, automatically the Supreme Court is bound any time an application for interrogatories is brought in an election petition to grant it. My lord, that is poor logic.
No, we are used to our jargons. Maybe you can say that it's misconceived.
Very well, my lord.
Yes, we are used to our jargons. We are
my lord,
other professions.
My lord, my lord is well taken. I withdraw that point. But my lord, I believe that it is completely misconceived to suggest that because in 2013 we were granted interrogatories, in this case we should be granted interrogatories. Again, the lords, my lords, I want to refer to the Nigerian decisions. My lords, and all the other decisions that were referred to in paragraphs 23, 25, and 26 or so of the statement of case. My lords, in all those decisions, the court, exercising its discretion, held that in the particular situation, the applicant was entitled to the grant of interrogatories, and therefore held that the refusal was wrong. So, my God, Lords, one cannot just cite those examples to determine that the refusal in this particular case was wrong. Again, the applicant has the burden of demonstrating to the court how the refusal in this particular case was wrong. And furthermore, he has an obligation to demonstrate, one, that the error was a fundamental error, two, that that fundamental error occasioned them a gross miscarriage of justice. And also, it's our submission that the applicant has failed to demonstrate these very basic conditions to grant a review. In the circumstances, my Lord, we pray that the application be dismissed as completely unmeritorious. Pray accordingly.
My Lord, yes, respectfully.
Because I think that as regards the first respondents, the opposition to the motion, it just like the
Mechanical, yes.
case.
Exactly. And my Lord, I was going to cite a more recent decision which made reference to the mechanical Lloyd case. Because, my Lord, I think it's important to...
Yeah, what is the case?
This is Hannah Asi number 2. Hannah Asi number 2 and Gihok Refrigeration. 2007 to 2008.
Yeah.
Supreme Court of Ghana Law Reports at page 16, which actually, it considers all the line of cases. My Lord, it was not in our statement of case. My Lord, I think you are referring to the draft of our supplements to the statement of case, which your lordships have thrown out of the window.
I would like Mr. Putampa to use certain words in the court of law, so please.
My Lord, with respect, I didn't say that disrespectfully. I use that word out of the window in a light-hearted manner, but if it's offensive, I take it back. I use that word just in a sort of light-hearted manner of, so I take that back as not reflecting perhaps the circumstances here. So I was simply drawing attention to the fact that Hannah Asi is not in our statement of case. That's all. Yeah. And I would also respectfully, in relation to the point that counsel for the second respondent made about the exercise of discretionary power, I would also respectfully refer your lordship to another authority of this Supreme Court in the case TDC and Musa against Atta Bafo. TDC and Musa against Atta Bafo. That is 2005 to 2006 Supreme Court of Ghana Law Reports, page 121. And in particular, His Lordship Dr. Barnes' words at pages 152 to 3. Now, my lords, you also heard counsel for the second respondent suggest that the issues that you have set down are the basis on which relevancy must be determined. With all respect, those issues that you set down were actually set down after the hearing of the application for leave. After. So, unless my learned friend was anticipating that those were the issues that would be set down, respectfully, those at the time of our application for leave, those issues have not been set down, and therefore it's illegitimate for him to claim that it is in terms of that application for leave that he's arguing. And finally, my lords, the reference that is consistently being made to strict timelines under CI 99, respectfully, my lords, we are saying that what the application sought to do was actually to facilitate those timelines, especially in terms of a judgment by March being complied with, because we're not waiting for things to be done in cross-examination and so on. And my lord, if you wanted to be literal and mechanical about the meaning of those timelines, we would draw your lordship's attention to one very simple example. The timelines put filing and serving of process of the petition in January, for instance. January is stated in CI 99, Rule 69C4. It says January, filing and service. Are your lordships going to say that because we filed on the 30th of December and the process was served by the 31st of December, therefore we do not comply with the strict timelines in CI 99? Are your lordships going to say that? I mean, my lord, with respect, this very simple way of trying to interpret Rule 69C4 would lead to gross absurdity if we were to follow it.
All right. Order, please, order.
And they call me UJ. Oh yeah, yeah. We just back to the next level. When you just shoulder to cry, run on my pampers, so we try was suicide. Yeah, if bygone be bygone. I didn't see what the button go do, we go straight to stardom. And I go take you to next level. Oh my baby, oh yeah, yeah, yeah. And I be next level. Back baby, oh yeah, yeah, yeah. I'll take you to next level. Oh baby, oh yeah, yeah, yeah.
I don't put this level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
So, when you're cheating, you're Nubians. What do you say, sir? It didn't catch you what you have to say.
And they the shoulder to cry. On my pumping, so I was suicide. Yeah, let bygone be bygone. I can't see what I'm gonna do. We go straight to stardom. I'm gonna take you to the next level. Baby, oh yeah, yeah, yeah. Energy next level. Baby, oh yeah, yeah, yeah. Take you to next level. Baby, oh yeah, yeah, yeah.
I don't quote this level. Excessive drinking can be detrimental to health. Not recommended for persons under 80 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
Oh, today he has been extra sweet, and the way he looks at me.
I have done everything by the book. It's on. Hey, but I have to get some condoms, Charlie. Using a condom will protect you and your partner from HIV, STIs, and unplanned pregnancy. Condoms are an effective way for protection against HIV infection. Don't take risks. Use a condom every time. Always come prepared.
This advert is brought to you by the Ghana AIDS Commission, Ghana Health Service, Planned Parenthood Association of Ghana, and the Adventist Development and Relief Agency, with funding from the Global Fund.
In Ghana, the law enjoins all drivers and passengers in a moving vehicle to wear a seatbelt. No excuse is good enough for not wearing a seatbelt. Seatbelts that are fitted in vehicles are adjustable, so please adjust it to suit you. Let it rest as close as possible to the body. As a driver, before you drive off, ensure everyone else, especially children in the vehicle, have fastened their seatbelts. The airbag is not an alternative to a seatbelt, because in the event of a crash, only the fastened seatbelt will stop a passenger from being thrown far forward. So buckle up. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
This advertisement has been vetted and approved by the FDA.
Good papa.
Ganabam, if your what your waist or your body, you make bazaar.
Thank you so much.
Welcome back. This is our coverage of the 2020 election petition here on GTV. We are also live on GBC News. We are live on radio, Unique 95.7. That is in the Greater Accra region and across 16 regions of this country, various regional and community radio stations. We're also live on Facebook, Ghana Broadcasting Corporation, and on internet, gbcghanaonline.com. We earlier saw a ruling that actually dismissed the applicant, that's the petitioner's supplementary application for review of the interrogatories, and that was actually dismissed. Now we also had arguments coming from the petitioner, that's the lawyer for the petitioner, arguing for a review of the earlier judgments which the justices have taken very to determine the outcome of that. We had a subsequent argument against that review argument that was put across by the petitioner's lawyer coming from the first and second respondents. We go back to Zoom and join our guest who's been with us since morning, Dr. Kwekwajiman Budu, who is a lawyer. He's also a law lecturer and the head of Law Center's GIMPA Faculty of Law, to give us a better understanding of what has taken place so far. Doc, good afternoon to you. Good afternoon, Doc. Hello, Doc. No, good afternoon.
Good afternoon. Unfortunately, I can't hear you through Zoom. There's no sound.
Oh, okay. But I mean, that means that you're hearing me now. Is it better?
Yes, can you hear me?
I can hear you. Can you hear me?
Yes, good afternoon.
Can you hear me now? Can you hear me? We'll quickly work on his line. We're going to talk to Dr.
So the thing is, I can hear you through another device, but I can't hear you through the Zoom, so it's making it difficult to communicate.
Okay. Through which device are you hearing me from? I'll work on his line quickly. That's Dr. Kwekwajiman Budu, who is a lawyer. He's also a law lecturer and the head of Law Centers at the GIMPA Faculty of Law. We'll quickly work on this line and get back to him. But some of the issues that play out during they just ended sitting. It's not actually ended though. The judges have gone into recess to come back for the ruling whether to actually review the earlier ruling that the petitioner said to have for some bit of interrogatories passing through. We saw the mention of CI 99. We also heard the mention of CI 47 and Order 22, which played a critical role in there, of which the petitioner's lawyer is actually seeking that the court looks at it. I mean, there's been some bit of argument also coming from the justices there. Let's go back to Zoom and see. Hopefully this time around the line will be that effective. We still don't have Dr. Kwekwajiman Budu there, who's still working on his line, and then when we get him, we'll put him on to find exactly what the issues are. If you're just joining us, it's our coverage of the 2020 election petition. It's live on GTV. It's also live on GBC News. We are live also on radio across the 60 regions of this country. We are live on Facebook, which is Ghana Broadcasting Corporation, and on the internet, gbcghanaonline.com. My name is George Sapo, and so far we've seen two incidents happen. The first got to do with the ruling by the justices after the petitioner's lawyer has argued for supplementary grounds to be given for their earlier request, and that was dismissed. And the second one has got to do with a review of the earlier ruling by the Supreme Court on 19certain issues regarding the questions that they wish to ask the Electoral Commission. That's after that ruling, the petitioners went in for a review, and that review has also been heard now. Arguments coming from the petitioner's lawyer, with counter arguments from the first and second respondents. Now the justices have just recessed now, and we're coming back with a ruling of that. In all this, the case itself is yet to be actually heard. The case itself, the case of the petitioner challenging the 2020 presidential results is yet to be heard. These are other applications that the petitioner filed to determine and get other issues ironed out for them. Let's go back to Zoom. I hope this time around we can have Dr. Kwekwajiman Budu back on Zoom. Doc, good afternoon. If you can hear me, I hope this time around is good. Hello, Doc. All right, we're still having some challenges. Let's quickly go for a quick break. We'll work on this line. We'll be right back. Stay with us.
advertisement has been vetted and approved by the FDA.
Hey, good papa. Ganabam, if your apostle, your waist, all your body, you make basa.
Thank you so much.
Ghana Power, young power to her. First at Tabakoti, after Chubi, 20 cities.
Nemo, second Ghana come. Sound two, we come Ghana.
Oh, Charlie, that's my friend over there. Hey, Azoto. Hey, what's up? Charlie, how? Charlie, did you go for the test we talked about the other time?
Oh, yeah, man, I do. I'm simple.
Oh, you do?
Oh, I do.
Hey, Azoto! I do. Charlie, this is great. Oh, guys,
pardon. This is my friend Azoto, another bold, wise person who is just taking the HIV test.
Wow! That's a wise decision, man. Azoto, we are bad man, Kasa. You be the man. You did for what?
That's really a respectable decision. When you're
Of course, it's time for testing. It's no big deal getting tested for HIV. The days of stigma are long.
There is life after HIV testing. Be bold. Get tested.
They call me Eugene. When you need a stroller to cry, one of my pumping, so we try was you side. I didn't see what I do, we go straight to start. I take you to the next level, baby, oh yeah. Energy next level,
I don't quote that level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
The small size of motorcycles make riders vulnerable. Your head is the most delicate part of your body. Your head is not much harder than a watermelon. In the event of a crash, if your unprotected head hits the street, you could suffer head injuries. Crash helmets are designed to guard against severe head injuries in the event of a crash involving a rider. As a rider, before you set off, wear protective clothing and a high visibility vest so you can be seen during the day and night. Make sure you wear a crash helmet to protect your head and ensure your motorcycle is in good condition. Ride safe. Stop road crashes now. Stay alive.
This road safety education is brought to you by the National Road Safety Authority.
Abusiafo tabia jumeko yasa babubu no biem na afeedie ye de tabia hand sanitizer e na abrewo oban pa betimi abo ho ban afiri mawa yemfa ye ni ehunu ho na epu 99.99% germs tabia ene nyoma ebeboa wo honam enkoa na ye tabia hand sanitizer e ma wo mfaso na esan bra wo nipadua.
Hey, sanitizer and alcohol ni 80%.
This advertisement has been vetted and approved by the FDA.
welcome back. And this is Ghana Television. This is also GBC News, and this is Unique 95.7. And you're listening to us across the 16 regions of this country. You're listening to us on our various regional radio and community stations of the Ghana Broadcasting Corporation. We have Dr. Budu back on the line. This time around, not Zoom, but on telephone. Dr. Budu is a lawyer, and he's a law lecturer too, and also the head of Law Center's GIMPA Faculty of Law. Doc, good afternoon. I hope this time around you can hear me.
Yes, I can hear you loud and clear.
All right, and thank you very much for joining us this afternoon. Thanks a lot for your patience and your time too. Let's move on to what has happened so far. First of all, we saw a ruling. Can you just help us understand the area ruling?
Which ruling was that? Because I didn't quite get
the first one.
I didn't see that. I think the network was off probably around that time.
It was a ruling on the request for supplementary applications to be allowed through that the lawyer for the petitioners had to argue out, but the judges came back and said that, well, they are not going to allow that bit of it. That was the first ruling. Yes.
I think counsel for the petitioner alluded to that in his closing submissions not too long ago. So let's remind ourselves generally what has happened so far.
Yes.
And so what it was that there was a motion for leave to do a number of things. The first was to file, that's the petitioner wanted to file an additional ground of review, and he wanted to replace one of the paragraphs in the original statement of case, that's paragraph 28, and then subsequently file a supplement to the statement of case, which, as you rightly pointed out, was probably not allowed by the court. So all this generally has to do with the application for review that the petitioner had filed earlier on, as a result of which they had initially not complied with the Supreme Court's directions in relation to the filing of the witness statements. So let's remind ourselves what this whole thing is about. It borders on the ruling that the Supreme Court gave on the application for interrogatories, which was given, I think, on 19 January thereabout. And in that particular ruling, the court... Hello?
Yes, I can hear you. Just go on.
Yes, in the ruling, the court clearly suggested that they were of the opinion that the crucial issue of relevancy had not been established in that particular application, and went on to talk about the fact that indeed reference had been made to the 2013 election petition, where an application to serve interrogatories were granted by the Supreme Court. But subsequent to that, there have been some amendments, in particular CI 99 has sought to restrict the practice and procedure of the court in relation to election petitions. And the court clearly said in the ruling that Rule 69C4 of CI 99 directed the expeditious disposal of election petition and set specific timelines for the courts to dispose of an election petition. And the critical part of the whole ruling which came up for discussion was the part where the court in this ruling suggests that it implies that even amendments ought not to be sought and granted, as well as joinder of parties. So they went ahead to state that they were strictly bound by the provisions in CI 99 and will therefore not apply Order 22 of CI 47, which is the High Court's civil procedural rules in this particular circumstances. So they refused the application on the basis of these reasons. So in the petitioner's original review application in relation to the interrogatories, where they wanted the courts to review its decision dismissing the application for the interrogatories, they argued three grounds. Three grounds were the grounds of argument that they had put up in the first place. They suggest that the Supreme Court erred in dismissing the application in respect to the interrogatories on three main grounds. And the three grounds were as follows. The first was that the court fundamentally erred in regarding CI 99 as rendering Order 22 of the High Court Civil Procedure Rules CI 47 inapplicable, thereby occasioning a grave miscarriage of justice.
Then they go ahead to talk about the fact that the court also fundamentally erred in determining that Rule 69(4) of CI 99 implies that even amendments are not to be granted. And this also, in their opinion, occasioned a grave miscarriage of justice in relation to the petitioner. Then their third ground of review was that the court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the 1992 Constitution. So what the petitioner was trying to do, or one of the things the petitioner was trying to do, was to first and foremost seek the leave of the court, essentially ask the court permission to file an additional ground to support their review application. So these three grounds that they had filed, that they were willing to argue, or that they had set their arguments in relation to, they wanted to add a fourth ground rather. And that fourth ground was that the ruling of the court was per incurium, Article 1294 of the Constitution, as well as the court's own decisions in Ex parte Magna International and the Bernard Mona and Attorney General case. What they mean by this is that the decision or the ruling of the court was without reference to the law, without reference to Article 129 as well, 1294, as well as other decisions of the court. And if you look at Article 1294 of the Constitution of Ghana, it vests in the Supreme Court all powers, authority, and jurisdiction vested in any court in Ghana for the purposes of hearing and determining a matter which is within that court's jurisdiction. And so, in the opinion of the petitioner, that provision, Article 1294, elevated the power to one granted to the Supreme Court by the Constitution, which, mind you, is the highest law of the land. And as a result, in an election petition, the Supreme Court will have the power by virtue of Article 1294, which sort of gives the Supreme Court residual power of all other courts in Ghana, to thereby grant or order interrogatories in the same way a high court acting under order 22 of CI 47 would do. So that's the first thing that they were trying to do, and that's the argument that they were making in terms of the additional ground of review, which I believe they argued to a large extent.
Well, before we continue, let's stay briefly on CI 99, CI 47, and Order 22 of CI 47. It looks like the usage on when to actually use CI 99 and when to actually use CI 47 or that 22 became an issue also there, and especially between the justices and the petitioner's lawyer.
So what the issue was, and so what the petitioner is essentially suggesting is that the grant of interrogatories is part and parcel of the pre-trial process, is part and parcel of when you're dealing with such cases of such nature.
Yes.
And generally, under the High Court Civil Procedure rules, Order 22 gives parties that leeway to serve interrogatories. And interrogatories simply are questions to which you demand or you require answers. And it sort of helps to narrow down the issue somewhat before you get to the trial or the hearing proper. So what the petitioner is arguing or was arguing was that CI 99 does not necessarily curtail the power of the court to still grant them their application in terms of the interrogatories. And this is because CI 99, in as much as it talks about there being strict timelines for the disposition of an election petition, the petitioner is of the view that nothing in CI 99 which amends the Supreme Court rules prevents the court from applying rules that may exist in ordinary trial and hearing processes that may help expedite the matter. So they cited the 2013 election petition and suggested that interrogatories were granted then. So to the extent that CI 99, which is the amendment to the Supreme Court rules, which came after the 2012-2013 election petition, to the extent that it does not specifically bar the Supreme Court
from ordering or granting them the application to serve the interrogatories, then the court erred when it suggested that they had to stick to the strict timelines, and because of that they could not apply, or they would not apply Order 22 of CI 47 in this particular instance. And that's what the respondents were also suggesting. I believe second respondent, that the court did not repealed or did away with Order 22 of CI 47, but rather the court was of the opinion that in this particular circumstances, order or grant the application for the interrogatories because of the circumstances of this particular case. Not that the court does not necessarily have the power to order interrogatories in line with Order 22 of CI 47. Is that clear?
Yeah, that's clear. Now, for the second argument that the petitioner's lawyer put across, and that's got to do with the main review of the earlier judgment on the 19th. Was that the case?
You said it had to do with what?
With the main ruling that they dismissed against the questions that they seek to ask the Electoral Commission.
So everything that has transpired here has to do with the application for interrogatories that were not allowed.
Okay.
So all that is being done here is that the petitioner is seeking review, and we saw that two other justices joined the panel to essentially hear the application for the review. All that they are asking is that ruling that the Supreme Court earlier on handed down, I believe somewhere last week, they wanted a review in the sense that the court had fundamentally erred on a number of things, and it is those grounds of review that they set out to argue. One of them suggesting that the court erred, and that's what we just talked about when they suggested that CI 99 they were not going to apply Order 22 of CI 47 because of CI 99, certain strict timelines for the disposition of election petitions. They feel that this is a great miscarriage of justice because they believe that nowhere in CI 99 does it do away with the power of the court to grant them the opportunity to serve interrogatories and receive answers thereof. So that's one of the arguments that they were making. Another argument that they were making, or they have made, is the fact that even Rule 69.4, which talks about expedition of election petitions, it cannot be said that it implies that amendments are not supposed to be granted. And to the extent that the Supreme Court in its ruling suggested that CI 99, which is the new regime for the dispensation of election petitions, does not allow amendments and join that. To the extent that it talks about amendments, they are of the view that that is not necessarily the case. And so that's why they sought to replace paragraph 28 of the original statement of case in support of the application for review. And that has to do with that particular ground of the review, which is premised on the petitioner's belief that the court fundamentally erred in determining that Rule 69.4 of CI 99, the one that talks about expedition within the timelines and in light of the second schedule to CI 99, implied that amendments were not to be granted. So to them, a grave miscarriage of justice was occasioned. And they argued that if you look carefully at CI 99, the only provisions that deal with amendments are Rule 68.7 as well as 69.A6 of CI 99. 68.7 only deals with the petitioner being prevented from amending the petition so as to add onto or alter the grounds of the petition. And 69.A6 is on the respondents, deals with the respondents and prevents them from amending their answer to a petition so as to add onto or alter the grounds or alter the answer to the filed petition. So the petitioner believes clearly that Rule 69C4
which says that the court shall inquire into and determine the petition expeditiously, and the time for the processes in relation to the petition shall be specified in the second schedule, has nothing to do with amendments, as the only amendment that seek to add it's only amendment that seek to add onto or alter the grounds of the petition or the answers that are disallowed, which means in their opinion, or in their respectful opinion, the court erred in its ruling when they said that the new rules CI99 did not allow for amendments. Then the third and final thing that the petitioners were trying to do is to file a supplement to their statement of case in support of their review application, and they made certain arguments, or they had outlined certain arguments that they hoped to make in relation to the grounds in that statement of the supplement that you rightly pointed out had been was not allowed by the court. So in a nutshell, these are some of the things that have transpired this afternoon.
From what has happened so far, I mean, from the beginning of the petition throughout the entire processes, I noticed that anything outside of CI99 is not allowed. Is that right?
You said from what has
transpired so far. I noticed that anything outside CI99 is actually not allowed in there, in the entire processes.
That's not necessarily what is being said. So, for instance, the petitioner is saying that CI19. So the court's ruling on 19 January said that to the extent they were not going to. They were strictly bound to comply with CI99, which is the Supreme Court amendment rules, and will therefore not apply Order 22 of CI47 in this circumstance. That does not necessarily mean that they would not apply it in any other circumstance. But for the purposes of this circumstance, the application for the grant of the interrogatories, the court was of the view that they would not apply it because they were bound by CI99. That is what the petitioner is now arguing, that nowhere in CI99 does it say that the court cannot apply the rules and Order 22 on interrogatories under CI47. And that's what the respondent, I believe the second respondent, was responding to and suggesting that the court's decision did not, or the court's ruling did not say that they would not apply the provisions under CI47 or under any other rules of practice of any other court at any point in time. But in the particular circumstances of the application that for interrogatories that the petitioner wanted, the court was not going to grant that particular application. That's what's essentially the thing in this particular instance. So I do not necessarily hold the view that
anything outside CI99
you're making.
Okay, all right. Let's talk about the whole review process. On what grounds will a review be granted, and what grounds will it not be granted? Let's have in mind that the first justices that sat on the first case, there's been an addition of 2. So if it's going to be granted, on what grounds will it be granted? If it's not going to be granted, on what grounds will it not be granted? We are not speaking specifically to this, but if you seek a review,
you're talking about the general review jurisdiction of the Supreme Court.
Exactly.
Reference first and foremost needs to be made to Article 133 of the 1992 Constitution, which is captioned power of the Supreme Court to review its decisions. And 1331 says the Supreme Court may review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by the rules of court. Then Article 1332 then says the Supreme Court, when reviewing its decisions under this article, shall be constituted by not less than 7 justices of the Supreme Court. So that's what the Constitution says. It sets out generally the power of review of the Supreme Court. If you look at the Supreme Court's rules, CI 16 of 1996, which is the original Supreme Court rules, that's the first Supreme Court rules that were enacted in the aftermath of the 1992 Constitution. Part 5 which is entitled Review, which is from rules 54 to 60 thereabouts. 54 says the court may review any decision made or given by it on any of the following grounds, 2 grounds. The first is exceptional circumstances which have resulted in a miscarriage of justice, and the second is the discovery of new and important matter or evidence which, after the exercise of due diligence, was not within the applicant's knowledge or could not be produced by him at the time when the decision was given. So what the petitioners are saying is that there are application grounds that there were exceptional circumstances which have resulted in miscarriage of justice. That's why if you look at their grounds of review, you're talking about the fact that the court fundamentally erred in talking about the fact that they won't apply or the 22 of CI 47 because of the strict timelines and the expedited manner in which CI 99 expects that election petitions are dealt with henceforth. We're also talking about the fact that the court also fundamentally erred when they talked about the fact that even amendments could not be granted because, according to them, nothing in CI 99 suggests the amendments cannot be granted. The only thing that talks about amendments in CI 99 is about the petitioner not being allowed to file amendments that alter or seek to undo any grounds that they have set out in their petition, or the respondent also doing saying that seeks to alter any of their answers to the initial petition. So that's something that they're talking about. They're also talking about the fact that, and this is all part of the exceptional circumstances which they feel have occasioned a grave miscarriage of justice, that the court fundamentally erred in failing to appreciate that its discretion ought to be exercised in accordance with Article 296 of the Constitution, which requires judicial bodies, including the courts, to exercise their discretion in a fair and candid manner. So those are the grounds, and that's what they believe are the grounds that suggest that a grave miscarriage of justice has been occasioned as a result of the dismissing of their initial application for the grant of interrogatories.
All right. And so it means that the court can review its own decision?
Yeah, that's what it means. The court can, I quoted Article 133 of the 1992 Constitution, which makes it clear that the Supreme Court may review any decision made or given by it on grounds and subject to conditions that are prescribed by the rules of court. And the rules of court have made those grounds given 2 general grounds: exceptional circumstances that result in miscarriage of justice, or where you discover some new and important matter or evidence that after due diligence you could not produce or wasn't within your knowledge during the initial application or the initial point in time where the matter was being heard. So yes, the Supreme Court may review its own decisions, and there are numerous instances that exist where the Supreme Court has even given judgment on a particular matter, but an application for review is nonetheless made, and the court has sat on that particular case of Ekwam Rosemary, Ekwam Pianim, which was a case that bothered on the 1996 election and whether or not Mr. Kwame Pianim, who was one of the leading candidates in the primaries of the New Patriotic Party, whether he was qualified to run as president or he was eligible to be president because of the fact that there existed a judgment that had been given by a court which sort of implicated him in an offense involving the security of the state, I believe in the early 1980s or late 1970s there about. And the court held that indeed initially that Mr. Kwame Pianim, on the basis of the Constitution's requirements of eligibility, that you could not hold office as president if you had been convicted of an offense involving the security of the state, that he would not be eligible to be president. And the matter had been brought even before the election had been done in terms of the primaries of the NPP, because according to Rosemary Ekwam, if he was elected as a candidate of the NPP, it was possible that he would be disqualified from contesting in the 1996 general elections. And dissatisfied with the decision of the Supreme Court, there was a review application that was made, and the court sat on that review, but essentially came to the same conclusion that the earlier panel had concluded in terms of the ineligibility of Mr. Kwame Pieni for running for office as president of Ghana.
Can we have any justice at all who ruled earlier granting for the case to be dismissed, and then in the review, that same justice this time around accepting what the petitioners have put across?
I mean, it's all a question about the arguments that are made in any particular instance. So you can make you can have an application which is dismissed, for instance, and you seek review and you make your arguments, and obviously other justices join the panel. We saw the two justices join this particular panel to hear the review, and it's possible. I mean, we can't go into the minds of the justices, but they are swayed or not swayed by the arguments that counsel presents. So it's possible that in one instance you may decide one way, but you may be persuaded subsequently by other arguments which may be superior, which you may end up changing your mind. There's nothing wrong with changing your mind. In fact, we've had instances where justices of the Supreme Court have changed their mind or have decided in one breath in line with a particular position, but in a subsequent case, not necessarily a review, so it's not particularly applicable. But that's just to show you that it is possible that a justice or a judge generally may make a decision on a particular matter at some particular point in time, and subsequently a different case will come, similar facts that may arrive at a different decision or a different conclusion, essentially reversing his own position on that particular matter. So there's nothing new or nothing necessarily wrong with that.
All right, so it means that justice can actually go back against his own earlier ruling in the same case.
Possible, depending on the arguments that are made. It's all, and that's what we need to dispel in terms of in the minds of the general public. You know, we hear all sorts of big biases and all that. But the justices do not sit there to do dispense justice on the basis of likeness or dislike for one party or the other. It's based on the arguments that you make. If your argument is superior enough to convince any judge for that matter, they very well may side with your arguments. It's just a question of perspectives, and it's a question of you making arguments backed by sound legal reasoning and legal authorities to sway the judge one way or the other. So that's the point that we need to make and make it quite clearly for everyone.
All right. How many reviews can the Supreme Court actually hear?
You mean how many reviews?
Yes, how many reviews? Let's say there's a ruling and you're not satisfied, you go for a review. How many of such reviews can you go for you to be satisfied?
So the review jurisdiction of the Supreme Court is a special type of jurisdiction. And we need to make it clear that a review is not the same as an appeal. And you saw counsel talk about that and acknowledge the fact that it is not as though you are trying to get a second bite at the cherry. A review is simply you going to the court, asking the court to review its own decision on the basis of certain exceptional circumstances that may have occasioned a miscarriage of justice, or you come across some new sort of information or evidence that you did not have at the initial time the application was being heard. So it's not something that you can abuse. And short of the rules or the law specifically prescribing that you can go for 2, 3, 4 reviews or something of that sort, it is my humble respectful opinion that once you have filed for a review and extra justices are brought to hear that particular review, it ends the matter then. Remember, the Supreme Court is the highest court of the land.
Yes.
And they have given their decision. You are dissatisfied
you are exercising your constitutional right as it may to ask for a review. The court comes back and gives its decision in respect of that review. So, for instance, in the Ekwam and Pianin case, when the review application was heard and it was decided, that brought matters to an end. So I hope that answers your question.
Or if you're not satisfied with the review of the review, what do you do?
It's the highest court of the land. It's given its decision. You live with it because the court is the government that is supposed to tell us what the law is. You have the legislature, the executive, the judiciary is that branch that interprets and the law, tells us what the law is essential. So if the Supreme Court is telling us that this is the law of the land, or this is the position of the land, you may think that it is erroneous, but until the subsequent case, which may be on all fours, has come before the court, where the court has an opportunity to review itself in quotes, and using review here loosely, or change its position, that remains the law. That ends the matter there and then. If it has to do with, for instance, a human rights situation, a human rights case, for instance, Ghana is a signatory to the Banjul Charter, the African Charter on Human and People's Rights, for instance, which provides for an African Commission on Human and People's Rights. Subsequently, there's the African Court on Human and People's Rights. So, for instance, in under the African Commission system, it used to be the situation that once you had exhausted domestic remedies within your domestic jurisdiction on a particular matter, if you feel your rights are being violated, will be violated, or have been violated, and you exhaust all domestic remedies, the sense of you essentially seeking redress in the High Court, you were not satisfied, you sought redress in the Court of Appeal, you were not satisfied, then you further went on appeal to the Supreme Court, you were not satisfied by the decision of the Supreme Court. Then under the Banjul Charter, you can bring an individual communication before the African Commission on Human and People's Rights to hear that particular matter. And I believe that it's been done several times. The case of, I believe it was Chachikata's case, also went all the way to the African Commission on Human and People's Rights, which essentially held that he had not exhausted domestic remedies, and as a result, they did not have jurisdiction. So those sorts of opportunities exist in some types of cases, like the example I've just given you, in terms of human rights, for instance.
You mentioned earlier that we need to declare that review is not the same as an appeal. Help us to understand the two.
So an appeal, in simple terms, an appeal is where the court saying has, and let me use an example. You have a land matter, which went before the lands court or the lands division of the High Court. The court has adjudicated upon the matter and declared or given its judgment on the matter that the land belongs to A or belongs to B or whatever orders that the court has given. Then you are dissatisfied with the decision of the High Court because you believe that in actual fact the land belongs to you. So you file an appeal with the Court of Appeal or at the Court of Appeal to hear the matter again, essentially take a look at the decision of the High Court and reverse itself. And for an appeal you need to have grounds of appeal. Some of the grounds of appeal that you usually see is that the trial judge had misconstrued the law or things of that sort. So the Court of Appeal...
Yes, we'll have to quickly just pause it here. I understand the justices are just coming back into the courtroom, so we'll move over to the Supreme Court. When we are done, we'll get back and continue that discussion. All right, thank you very much. We just heard from Dr. Kweku Adimanbudu, who is a lawyer, and he's also a law lecturer and the head of law centers at the Gimpa Faculty of Law. Let's take you back to the Supreme Court. The justices are getting seated.
All rise.
This is the ruling of the court. The review jurisdiction of the Supreme Court, as conferred by Article 133, Clause 1 of the 1992 Constitution, and regulated by Rules 54 to 60 of the Supreme Court Rules 1996/16, has set down the threshold that the applicant has to satisfy in order to succeed in an application for review. It is a special jurisdiction conferred on this court. The threshold are A, exceptional circumstances which has resulted in miscarriage of justice. B, discovery of new and important matter or evidence which after the exercise of due diligence was not within the applicant's knowledge or could not be produced by him at the time when the decision was given. We have read the processes filed in this application and have listened to counsel. We are not satisfied that the applicant has met the statutory requirement of Rule 54A of CI16 in order to succeed in the application for review of the ruling of this court dated 19th January 2021. The application fails and it is accordingly dismissed. The panel will be reconstituted to give further directions for the trial of this petition.
As the court please.
No, you bring it. You bring it there. You bring it there. Yes.
All rise. You may resume your seat, please.
Charlie, did you go for the test we talked about the other time?
Oh, yeah, man, I do them simple.
Oh, you do them?
Oh, I do them.
Hey, Azoto! Charlie, this is great. Oh, guys, pardon. This is my friend Azoto. Another bold, wise person who is just taking the HIV test.
Wow!
Why is this?
Azoto, we are Berman Kassan.
You be the man, you there for what?
That's really a respectable decision. When you be.
Of course, it's time for testing. It's no big deal getting tested for HIV. The days of stigma are long.
There is life after HIV testing. Be bold. Get tested.
Alright, welcome back, and you just heard that the application for review has been dismissed on 2 grounds, which the justices gave out. The first has got to do with exceptional circumstance, that there have been miscarriage of justice, which the judges thought that, well, that has not happened in the first ruling. And the second one has got to do with discovery of new evidence that would affect or even have some bit of implication on the earlier ruling, which again, the panel thought that has not been well established by the lawyer for the petitioner. So, in all, the application for the review has been dismissed. Now, this is what's going to happen. We're going to end our broadcast, the court proceedings on GBC News. They'll make way for our news bulletin. But it's going to continue on GTV. Right, so you get an opportunity to watch it on GTV when the justices get back from the reconstitution of the panel. This time around to make it 7. That's going to be on GTV. But for now, we're going to go off on GBC News to make way for the news. The 2020 election petition will still be aired live on GTV, likewise on radio and on Facebook. But for now, we're wrapping up on GBC News. So those watching us on GBC News, you have the opportunity to stay with us to watch our news bulletin or to move to GTV to continue with the proceedings. My name is George Sapo. I'll see you again when I see you. Good afternoon. Bye-bye.
And now, my dear listeners, Before I sign out, I would like to introduce to you Tabia Herbal Mixture, a great and effective herbal medicine for malaria, loss of appetite, and general body pains. Tabia, a fact I can personally attest to.
Asana udano Tabia Herbal Mixture. Should we do say when you chew the Arabians? Tabia Herbal Mixture. Do you say it doesn't cancel what you have to say?
So we try was suicide. Let's buy on the Bible. I can't see what the bottom of the movie go straight to start. Take it to next level. Energy next level.
I don't go next level. Excessive drinking can be detrimental to health. Not recommended for persons under 18 years, lactating mothers, pregnant women, and people sensitive to caffeine. This advertisement has been vetted and approved by the FDA.
With me, Winifred Efum. We start off from the court. The Supreme Court is on Thursday, January 28, 2021, hearing the application for former President John Mahama, asking the court to review its decision that disallowed him from asking the Electoral Commission (EC) 12 questions in the 2020 presidential election petition. Two additional justices, Justice Imoro Tanko and Justice Henrietta Mensah-Bonsu, have been added to the earlier 7-member panel for the review application. The 7 other justices on the panel hearing the petition to determine whether or not President Akufo-Addo is the validly elected president of Ghana are the Chief Justice, Justice Kwesi Enin-Yeboah, Justice Yao Apel, Justice Samuel Kofi Mafo-Sao, Justice Professor Ni Ashikote, Justice Nene A.O. Amegache, Justice Gertrude Tokonu, and Justice Mariama Usu. On Wednesday, January 27, 2021, the petitioner in the 2020 presidential election petition, former President John Mahama, filed his witness statement at the Supreme Court. Mr. Mahama, who was the presidential candidate of the National Democratic Congress, NDC, in the 2020 elections, also filed an opposition to the preliminary legal objections filed by both respondents. That was after the Supreme Court had given him the last opportunity to file his witness statement in the petition by the close of yesterday, January 27, 2021. The witnesses are a senior lecturer at the University of Ghana, Dr. Michael Pesa-White, and the General Secretary of the NDC, Mr. Johnson Esiedum-Ketia. While Dr. Pesa-White, who described himself in the statement as a representative of former President Mahama's strong room, said he noticed many material irregularities during the entire process of the December 7 presidential election. Mr. Esiedum-Ketia, in his statement, alleged that certain officials of the Electoral Commission padded the votes of President Akufo-Addo.